Afarian versus Mass Electric Company.
Good morning, Mr. Talcott.
May I begin?
You may proceed.
First, Your Honor, I believe I was given 20 minutes.
I believe you were.
Okay. Good morning. My name is Anthony Tarracone. I represent the plaintiff appellant, Ketcher and Marianne Afarian, administrators of the estate of Peter Afarian. With me is Joseph Masacchio. The first issue before the court is whether the defendant utilities owed a duty of reasonable care to Peter Afarian with respect to the placement of a single utility pole on Route 133 in Andover. The case involves an accident, an automobile accident, on July 28, 1986. The subject pole was erected in 1968 under the authority of General Laws, Chapter 160, Section 121. It's a single pole in a long line of poles. The pole was moved in 1968 from the north side of the street to the south side of the street. It was placed 6 inches from the curb in an area where the right-of-way extended another 40 to 50 feet beyond where the pole was located. And there was some dispute in one of the briefs about the distance of the right-of-way, and I would refer you to Appendix 1011-1011, where there is a drawing and there are measurements, and you will see that 1 1/8 inches is approximately 50 feet, and that the distance from the pole to the end of the right-of-way is 1.5 inches. So it was more than 40 feet. When the vehicle that Mr. Afarian was riding as a passenger struck the pole, the vehicle was 1 foot off the traveled portion of the roadway.
Was there a curb, a physical curb between the pole and the roadway?
Yes, there was a standard
granite
type curb. Okay. Yes. You will also see, if you look at Appendix 605 and 606, drawings that were rendered from 605, rather from 1011, that show the distance of the other poles on the other side of the street from where this one was removed. And because they're difficult to read in the record, I actually had the original exhibit reproduced in color, which I will hand to the court with the court's permission.
Certainly.
And we have copies for counsel. And you will see that the poles on the other side of the street are all at least 4 to 5, some 6, some 7 feet from the curb. So this was a unique installation of a pole. It was not a new installation of electricity. The pole was not erected to provide electrical service to a particular piece of property. The pole was moved for no reason that was offered by anybody that's anywhere in the record.
But you'd be making the same argument if the car had hit one of the other poles, wouldn't you?
No, absolutely not. We're not asking the court to impose a duty of care with respect to any pole. One has to look at all of the considerations, and here there is a right-of-way that allowed for this pole to be placed at a great distance away from the road. The defendant's own practices, as they've admitted in their testimony, was to, in fact, put the pole as far as they can away from the road on the right-of-way. But let's just look at the fundamental principles that this court has articulated for determining whether a duty should exist. And I would suggest that the Jupin case is a good starting place. We should be looking at the sum total of policy considerations here. And I believe the best expression is the very statute that authorized the erection of this pole, Chapter 166, Section 21. It permits the installation of a pole, but it has this clause, and I quote, "But such company shall not incommode the public use of public ways." This court in 1960...
Mr. Tarracone, let me ask you this. If the pole had been located on the opposite side of Route 133, then wouldn't it then be on the outside of the curve for cars going in the opposite direction, that is west on 133?
Well, no, because of the way the road curves. It's still on the inside of the curve. The natural way that a car would go off the road at a curve of this nature. This pole was
For cars
placed...
going in the opposite direction?
Well, first of all,
If
on the other side, on the other side, it was not, where it was not 6 inches or 1 foot from the road. It was placed well back.
No, but if it were 6 inches, forget the distance from the road. If it were on the other side of the road, would it or wouldn't it be on the outside?
I suppose it would for cars coming the other way.
So for
That's
cars,
right.
so it has to be on the outside for cars coming one way or the other on the
Yes.
outside of the curb?
Yes.
Okay.
But the point is that there was plenty of room to put it elsewhere. In the Boston Edison versus Board of Selectmen of Concord case in 1968, this court interpreted Section 21, and I quote, the court was not inclined to adopt a restrictive meaning. The court said that broad connotations include that which may cause any insignificant physical inconvenience or danger to the traveling public. This is an expression of legislative concern about the danger of utility poles placed by utility companies, private utility companies, on the roadways in the Commonwealth. This statute was enacted in 1849. It was amended on multiple occasions, most recently just a few years ago in 2000. That language has remained intact through every one of those amendments, as pointed out by that court, and in 2000, when it was amended again, that language remained. It's a long-established, recently affirmed statement of legislative concern, and it's further buttressed or supported by the Massachusetts Department of Public Works Public Utility Accommodation policy written in 1972, which says that poles should be placed as far away from the road on the right-of-way as possible. And
Well, this is a state highway, isn't it? Route 133?
Yes, it is.
Road. Well, so why isn't DPW in charge of this?
Well,
Why shouldn't-
DPW does have this guideline, and
So why don't they enforce it? Isn't that the right way to?
well, the permission to put the pole up is still under Section 21. The guideline that's issued by the DPW, I don't believe, is one that they can go out and enforce. For all I know, they may not have had notice of the erection of the pole because the permission has to be obtained through the town, not from the state. But it is a statement of public policy. The second influential consideration here is foreseeability, and I suggest to you, if you look at the Bernier case, which was decided in 1980, it stands for the proposition that the particulars of why the car went off the road, that is, whether the driver was intoxicated, fell asleep, playing with a radio, sending a text message, is irrelevant. What matters is that it is foreseeable that there will be motor vehicle pole impacts.
May I interrupt you for a moment?
Yes.
I read in your brother's brief a statement that they had information that over 5 million vehicles had driven past the pole. Did you see that?
Yes, I did.
And not one other accident there. So how doesn't that reflect on foreseeability? You have 5 million cars that drive by there without an accident. It's not foreseeable.
Well, several points, Your Honor. First of all, the defendant had the burden of proof on that issue on their motion for summary judgment. The evidence should have been examined in the light most favorable to the plaintiff. The record shows that the defendants did not maintain records of accidents at this pole, and it's very clear in the record. And let me refer you to Appendix 956, 957, where the Mass Electric Company's 30B6 designated deponent testified as follows. The question was asked, is it fair to say that given the way Mass Electric Company keeps its records, it would be impossible definitively to determine every repair or replacement made to a particular pole between 1969 and 1977? The answer was extremely difficult, yes, very difficult. And that testimony is throughout the record. In fact, in the Commonwealth of Massachusetts, if you look at the plaintiff's expert, there are 64 fatalities a year with motor vehicle impacts. There are 64,000 motor vehicle impacts annually in the United States and 1,100 fatalities annually in the United States. This particular pole was 6 inches off the road. We have no record of other accidents, but there is no record of there not being another accident, and that's the point, and the burden was on the defendant. Beside which, evidence of a lack of a prior incident is very poor evidence, and this Court has so held on many occasions.
Mr. Talcone, let me ask you this. The placement of poles receives prior approval, correct?
Well, only in a very general sense. What happened here and what the record shows is that the utilities had to ask permission to erect a pole from the town, and then the utilities decide where to put the pole. So that is what the record reflects. The
So
town,
they say we want to light this road, or we want to provide, a utility. There's no location identified?
what the record shows is they asked permission to erect the pole, and then they...
Where?
On that side of the street. And then the utilities chose the location of the pole. They claim that the two utilities conferred together and decided where to put it. They've also testified, Your Honor, that notwithstanding their knowledge of federal guidelines, state guidelines, industry guidelines, and even their very own practice of placing the pole on a curve as far from the road as they can within the right-of-way, having acknowledged all of that, they offer absolutely no explanation for why they put the pole where they did. And that was from the testimony of multiple 30B6 witnesses from both of the utility companies. Let me just address the Bernier case. Justice Kaplan, I can't say it better, but the chain of events here is just absolutely striking. Justice Kaplan wrote, "What might have been a commonplace collision turned into a complicated accident. On impact, the driver hit her head against the steering wheel. She lost complete control of the car. Dazed, she unknowingly let her foot slip from the power brake to the gas pedal. In the result, after veering around the other car and perhaps slowing, she accelerated across the remaining 20 feet of Muzzy Street, bounced to the south sidewalk, about 9 feet wide, of Massachusetts Avenue, and moved 55 feet down the sidewalk. The car scraped the front of a camera store, hit and leveled a parking meter, struck and damaged extensively a Chevrolet Chevelle automobile, knocked down an electric light pole owned by the defendant, Boston Edison, and struck the plaintiffs who had left the ice cream parlor. The car came to a stop. The electric light pole, when hit, fell away from the car toward the east, struck a Volkswagen automobile on Mass Ave, and came down across the legs of the plaintiff." And what the court ruled there is that the particulars of that accident, which are far more tenuous than in this case, are not relevant on the question of whether there's a duty for purposes of foreseeability. The issue is whether it is foreseeable that there will be motor vehicle impacts with utility poles. And the court said, impact of a car with a pole could be expected to occur as a result of driver negligence, and the design of the pole must take such mishaps into account.
Can I interrupt you for a minute? I don't want to take
Yes,
you
Justice.
off your argument necessarily, which is all about whether negligence exists. Are you going to get to the statute of repose?
If that's where you want me to move, I will move
Well,
there
no,
immediately.
but didn't the judge rule on both grounds? No
Yes.
negligence and the statute bars the claim?
Yes. Let me just finish on the duty issue with this. The judge ruled that there was no duty. I would submit that the question of alcohol, of the speed of the car, and every other detail about the accident is a question of proximate cause that should have been submitted to the jury. The general foreseeability of the general risk of harm in the class of persons, that is the traveling public, is evident in the record and really not disputable.
Well, isn't the duty to place a pole such that it doesn't create an unreasonable risk to one traveling with reasonable care? Isn't that sort of what the restatement says?
No, that's not what it says, Your Honor. I would suggest Section 435 says the precise manner of the accident need not have been foreseeable if impacts by moving vehicles were. That's Section 435.
I'm talking 368, dangerous conditions to travelers on adjacent highway.
I would suggest, Your Honor, that Section 368 is really not a useful provision for this Court. This Court should abide by its traditional analysis of whether a duty exists. Section 368 is not a foreseeability standard or a duty standard. It's a liability code. So it wraps everything into one. It is for jurisdictions that are rather contributory negligence jurisdictions rather than comparative negligence jurisdictions. Any negligence at all on the part of the driver in that under 368 defeats liability. Don't forget, Peter Afarian was not driving this car. He was a passenger. He was lawfully on the roadway as a passenger in that car.
I understand, and I understand how tragic that is, but so wouldn't your argument apply to a fence or a wall or anything placed close to the curb?
My question is, wouldn't your argument apply to all the utility poles throughout the Commonwealth? Because it's reasonably foreseeable cars will go off the road all the time in any place, and unless the poles are way back from the road, and you're saying...
Absolutely not, Your Honor.
Why not?
We're not suggesting that every pole that's close to the road gives rise to a legal...
Why is this pole different from other poles?
This pole is different because it's on a curve, because the right-of-way extended 40 feet, because the pole was placed there under the statute, which specifically says that it shall not incommode the use of the road by the traveling public.
But what you just read us from Justice Kaplan, it seemed to me, suggested that any light pole would be in the wrong place because it's reasonably foreseeable that a car would come off the street and hit the pole.
What Justice Kaplan ruled, I believe, Your Honor, is that the case should be submitted to the jury. The jury should decide whether the conduct of any of the actors involved, whether there's a superseding intervening cause, whether there's comparative negligence, and whether there's a substantial
But you're
cause
saying
of
whether or
death.
not there's a duty should be submitted to the jury.
That is for the court, Your Honor, yes.
Oh, well, I thought you were saying whether or not there's a duty. You're asking me to look at the totality of the circumstances to find that there's a duty, correct?
Yes,
but
Your
that's a legal determination.
That's right. And I would say on the duty, there are multiple considerations. The first is legislative expression of public policy, which we have in Section 21. There is no legislative policy on the other side that says that there shouldn't be liability in a situation like this. Also, there are standards from which a jury can judge the conduct. There are multiple standards listed in the plaintiff's expert's affidavit, federal standards, state standards, industry standards. They all say exactly the same thing. Place the pole as far from the road as possible on the right-of-way, especially on curves, and leave what's called a clear recovery zone. This is something that's well known in the industry and has been for years, and the defendants have acknowledged it. Another reason here is that it would not have been a difficult burden for the defendant with respect to this pole to have placed it elsewhere. They've offered no other explanation. And I would also suggest that the defendant itself foresaw this type of an accident at this location, and the testimony is very clear from the defendant. And let me just read very quickly. Would you describe for me what it includes? And this is the reference to the Massachusetts utility accommodation. Answer. This is a 30B6 deponent. It talks about clear zones, recovery zones, and many other things. It incorporates a lot of various utilities, some considerations for all kinds of utilities. Is it fair to say that the document addresses highway safety? Yes. Does it address the issues relative to safety of the motoring public? I would say that's a fair assessment. Does it address ways in which highways, including the placement of utilities, can be designed to minimize the risk or danger to the traveling public? Yes. And you have a copy of that? Yes. Another witness said, how does Mass Electric take the safety of the motoring public into consideration? Answer, and this is on page 859. The placement of poles naturally has to be off the traveled way. That's the first factor. There's a concern on bends in the road as to where you place the poles. We would typically try to place them as far back as practical in the placement as we place these poles. When you say you consider bends, what do you mean by that? If the person was to lose control on the outside of a curve, they would typically go off the road. So that has to be given some consideration as to where these poles are located, and so forth and so on. This wasn't some surprise. This was foreseeable by them. They foresaw it.
Now this will all be academic if the statute of repose applies.
Yes, it will. Let me move to the statute of repose.
Because you've only got a minute left.
There are three considerations for the statute of repose. It has to be a protected party. There has to be an improvement, and the improvement has to be a real property. This case, this court, rather, has examined Section 2B on multiple occasions, and it has ruled, and it is clear that the statute does not typically apply to a party that does some work on real estate and then relinquishes control to the owner. The intent of this statute, which was passed to protect architects in engineers when the law that traditionally protected them was beginning to be eroded by judicial decision. The legislature stepped in, and there's a long legislative history that's laid out in the Klein case, Klein versus Catalano, and also in the Dighton case. And those cases make clear that the purpose of the statute is to protect someone who relinquishes control and no longer has control of the property.
Yeah, you're suing these folks as owners of the pole.
They own the pole.
They own the pole. You're not suing their engineer.
No, we're not. They maintain this pole day in and day out, year after year. They have maintained this pole. There's no improvement to real property. The only property interest here is the Commonwealth's right-of-way. The pole is a nuisance on the right-of-way. It's not an improvement or enhancement to the right-of-way. The only benefit here was to the utilities' ability to generate their profit.
Well, 2B doesn't allow the owner to escape liability for maintaining a hazardous condition on their property, does it?
No, and there's no property, and the only thing they own here is the pole. So 2B just plain doesn't apply. May I briefly address the other defendant, the Demoulas case?
I don't think you're going to have a chance to do that.
Is that my 20 minutes? Or is
That's your 20 minutes.
Thank you, Your Honor.
Thank you, Mr. Talcon. Now, who do we have? Mr. Milletti, you have 6 minutes, 7 minutes.
Thank you, Your Honor. Paul Moretti on behalf of Demoulas Supermarkets. With me is Chrisanne Leal. The issue before the court with respect to Demoulas is whether the judge abused her discretion in denying the plaintiffs the opportunity to amend their complaint a third time to bring in a new defendant and a new set of factual circumstances. And since what the court will be, this isn't a de novo review, and what the court will be doing was reviewing the judge's decision with respect to whether her discretion was sound, I think we have to look at what she actually found. And what the judge found was that there was undue delay in the plaintiff seeking this amendment because in 1999, Jason Vellieu, the driver of the car, had testified by way of deposition. And he testified where within the store, the layout of the store in which the beer was purchased. He testified that the beer was purchased, and the beer and wine section of the store was on the left side of the store.
That testimony is very, I mean, I mean, the transcript of that portion of the deposition is included in the briefs, is it not?
It is true.
Boy, I'll tell you, it's a multi-part question to which he says, yes, I think so. I mean, that's hardly testimony that is clear about where the beer section was.
No, I think I'm sorry, Judge, but I do think it was clear. And it had always been our defense that this was not, it was Market Basket's defense that this was not the store in which the beer could have been purchased.
I understand that.
And that was the reason why Market Basket supplied a layout of the store showing that the beer was on the right-hand side. So it was known, and I think it was clear as to what Market Basket's position was, and it should have been knowable or readily knowable to the plaintiffs, as the judge found.
What prejudice did you show to the motion judge? Did you present evidence that some employee who might have had information had left your employ?
Well,
or that you had done any investigation? Or
well, yes, Judge. I mean, with respect to Market Basket, they were able to identify employees that had worked on that particular day. It had been so long that we are unable to identify any employees that were working at Demoulas.
Did you present evidence? Did you present evidence that you couldn't locate the salespeople, or that you couldn't figure out who it was, or that records were destroyed?
No, there was no affidavit or deposition testimony or anything like that. But one of the considerations, Judge, and as the Court knows, I mean, because this happens quite often.
Can I just go back, I'm sorry, to that, the answer to that question? Why does it make a difference, given the corporate structure here, why Demoulas or Market Basket wouldn't know who was employed at that time?
Well, that's a very good question. Well, first of all,
you can go on to answer Justice Cowan, but you said we don't know who's employed, but you've essentially got a corporate structure here, correct?
At the time that Market Basket was brought in, there were records, payroll records, that were available in order to identify the employees that were working at the Market Basket store at 167 Broadway in Nashua, New Hampshire, and who they were. At the time they sought the amendment, in 2004 to amend the complaint to bring in Demoulas concerning the Demoulas supermarket store at 265 Broadway in Nashua, New Hampshire. There were no records available in order for Demoulas to identify what employees were working on that particular
But
day.
did you present evidence to the judge that you had done some investigation in regard to the store that you thought was involved?
No.
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 So
No.
what basis then is there
Well, that's
to
what
find that you were prejudiced?
That's a good question, Judge, and that's what I was getting at. One of the considerations for making this determination, although once a party is brought in, there would be relation back, and I understand that. But one of the considerations is the time that is involved and the statute of limitations and the purpose of the statute of limitations in the ability to identify witnesses, in the ability to have recollections that are clear. And here we are in 2004. This was 8 years after the accident happened and 5 years after the complaint was brought. And it was impossible to determine who worked on that day or to identify them.
Mr. Muletti, maybe I could ask the same question differently. I'm looking at the judge's findings, and she keeps talking about the prejudice to Demoulas, but she doesn't tell me why they're prejudiced. I think that's the
That's what I'm trying to ask. Was there evidence to support the judge's findings here on prejudice? Because I don't see it, and I don't see it from what you're saying. You're saying it was absolutely impossible, but you didn't present evidence to support that it was impossible.
Well, what she says is Demoulas would have great difficulty when attempting to determine who worked at the store on that day of the accident and the alleged illegal sale 8 years, and when attempting to gather relevant evidence. And that is true.
I understand that's what she's saying, but what evidence supports that finding?
Well, there is no deposition testimony, or there are no affidavits or anything like that, Judge. They were just the arguments of the parties at the time.
Also, I was just wondering, perhaps I should have asked Mr. Tarracone this, but in discovery, did the plaintiffs ask for receipts showing the beer that was sold at the store that day?
There was, with respect to the Market Basket store, you have to realize that there had been no discovery with respect to the Demoulas store. Market Basket actually tried to obtain the receipts for that particular day, and they weren't available. For this particular store, with the type of registers they had at that time in 1996, which is different than what they have today, the receipts were only kept for a certain period of time in which they could verify whether the cash, when they did the cash out, was correct and all the transactions were accurate. So they were only kept for a matter of days, or at the most a week.
So there wouldn't be those receipts to show that?
No,
that would answer the question, probably.
For the Market Basket store, no, there would have been no receipts. Now, the Demoulas store is completely different because they had something that I think that was a little bit different. But now that we're 11 years after the accident, or at the time that they sought the amendment, 8 years after the accident, there would have been no receipts that would have been available. I do want to make one comment in my 23 seconds that is left, and that's the notion that the case of Demoulas versus Demoulas, or that Demoulas being a successor to Market Basket is some way important here. It is not. The plaintiffs were not seeking the amendment to add Demoulas
as the parent. It was a different
right,
story.
as a successor to Market Basket. What they were seeking to do was to add Demoulas as a separate defendant for the owner of a different store that was down the street for a separate transaction that could have occurred. It's no different than if they were trying to bring in Cumberland Farms, Hannaford's, Shaw's, or Stop and Shop.
No, I understood that. That's clear.
And
yeah.
I thank the Court.
Thank you, Mr. Muletti. Ms. Perrine-Sweet?
Good morning, Your Honor. May it please the Court, I'm Andrea Perrine-Sweet, and with me is Francis Sally on behalf of Massachusetts Electric Company. Your Honors, in 1969, Massachusetts Electric Company and the telephone company, their engineers, engineered the location of a new utility pole on the southern side of Route 133 in Andover, Massachusetts. They did this under the license that was granted from the town of Andover with the permission of the town of Andover.
And they put it very close to the curve in the road.
They did, Your Honor. They did put it 6 to 8
And
inches.
is there any evidence to suggest they couldn't have put it further back?
There's no evidence to suggest in the record, Your Honor, why they put the pole where they put the pole.
But
However,
do we
Your
have
Honor,
to bother with that? Doesn't the statute of repose kill this off?
that's where I was going, Justice
I mean, it's
Sweeney.
not just limited to owner. The fact they're suing owners, the statute on its face applies to everyone. as long as there was some engineering involved, and there was engineering involved.
Indeed, Your Honor. The statute of repose protects activities as opposed to particular individuals. And the activities that the statute of repose protects are engineering, design, construction activities, the very activities that the engineers from Mass Electric and the telephone company did in this particular case. And in fact, if one looks at the legislative history of the statute of repose, which is set forth in Klein versus Cataldo, this indeed is the very issue and problem that statute that the legislature was looking to address, which is that after a certain amount of years, and the legislature determined that that was going to be 6 years as a period of time, there needs to be a limit. There needs to be a limit on
There needs
liability.
to be a limit with the structure that is going to be used. I have no doubt whatsoever that the statute of repose might apply if, in fact, the issue here was the failure of the lighting, right?
Okay.
But the suggestion that you can have 5,000 cars and the 5 million cars and the 5 million and first car, there's an accident which was foreseeable. Let's assume that it was foreseeable. I'm not getting into that for the moment. It seems to me that that's not what the statute was designed to do.
Your Honor, I think that what the statute was designed to do was to protect the initial engineering activities.
Yes, so if the pole falls down in the middle of the night, or the bulb goes out, or if the pole itself malfunctions, that's what the statute of repose is designed to do. The engineers, the architects, the roof falls in, that's what the statute of repose does. It's not designed to protect. You can't say there's no statute of repose because a plane crashes into the building. Well, there's a statute of repose.
No, with all due respect, Your Honor, we're not saying that. If there was evidence in the record, and there is no such evidence, that this pole was negligently maintained.
No. Plane flies into it.
Yes,
Plane
Your Honor.
flies
You've got
into
to
it.
look at the plaintiff's complaint, and the complaint, is it not, is a complaint about negligence in the design and construction and placement of the pole.
That's correct, Your
Not
Honor.
in maintenance or in anything else.
That's correct, Your Honor, and
Not
we're
in
addressing.
giving warnings about the pole or anything else. And the statute talks directly about neglect in design, planning, construction, or administration of the improvement.
That's correct, Your Honor, and that's
So
all.
you fit those two together, and it fits the statute.
Was there any evidence in the record that the placement, the particular placement of the pole, was a matter of an engineering decision, an engineering determination?
Yes, Your Honor, there was evidence in the record. There was testimony both from the 30B6 witness from the telephone company, as
And
well
why was it placed there?
as the testimony in addressing Justice Spina is that I understood his question was there evidence of engineering, and yes, there was evidence that engineers from Mass Electric and New England Telephone went out and engineered and looked at this site and determined where the pole was. Was there evidence as to why they put it 6 to 8 inches from the roadway in the record? No, Your Honor. There is no evidence in the record as to why they put it there, why they didn't put it 10 feet, why they didn't put it
And I
5
assume
feet.
there's no evidence in the record either as to why it's 6 to 8 feet or
Inches.
I'm sorry, rather than the pole that had been there on the other side was much further back.
Actually, Your Honor, there is no evidence in the record as to exactly how far the pole on the other side of the roadway was from the roadway. What the evidence is in the record is that there was an engineering of a new pole on the southerly side of Route 133 done in 1968, and the pole was set in 1969. And that pole then stood there for 27 years, uneventfully, with no incident or no accident
I
until
take
this
it your
tragic
position would
accident
be that
happened.
with respect to any polls, any place in the Commonwealth, after the requisite number of years that the statute of repose imposes, there can never be any liability.
No, Your Honor, that goes beyond what we're asking this Court.
Well, you explain to me where the limit is.
Certainly, Your Honor. What we are saying, Your Honor, is that in an instance where engineering activities have occurred, where a pole has been set, just that activity comes within the statute of repose. For example, Your Honor, if, and there is no evidence in the record of this, if any pole had a history after it was set of being struck, of being involved in accidents, then that is a very different issue. And in fact, Your Honor, that would be the case of Marino versus Nynex, where indeed the telephone company was on notice of accidents that had occurred in that particular instance, where there was evidence of the roadway was pitched in such a manner that caused cars to veer off and hit that roadway.
But as I understand Mr. Talacone's argument, your client didn't keep any records of whether or not there was any damage to this pole.
There are no records of whether there was damage in the pole. What the part of the record that Mr. Tarracone did not quote to you was when the 30B6 witness from Mass Electric Company was asked whether or not he was comfortable or he could say with certainty whether this pole had ever been replaced. The answer to that question was yes, he was fairly comfortable.
No, that's replacement. That's a different issue.
And that's what we're talking about, Your Honor, is the replacement to this pole.
No,
the
but
engineering
Mr.
to the pole.
Tarracone, I believe, what the Chief Justice is referring to is that he indicates in his brief, and I have not read the record, but that your records are insufficient to indicate whether there had been any accident or damage to this particular pole.
He does indicate that, Your Honor. And again, Your Honor, there is nothing in the record to suggest that this pole was ever struck or ever repaired by both Mass Electric and the telephone company.
But his answer to that is that there's nothing in the record to indicate that because you don't keep records that would show that.
I understand that. We have records. We didn't have records that showed that. And if I could finally just very briefly say that, Your Honor, this was a Rule 56 summary judgment motion, Your Honor. After we brought forward our evidence, the burden shifted to Mr. Tarracone to bring forth evidence to suggest that it was reasonably foreseeable this pole was hit, and we would suggest and submit that that didn't happen in this case. Thank you, Your Honor. I yield to Mr. Alcott to continue the argument for you.
Thank you. Mr. Alcott?
Good morning. If it may please the Court, my name is Tom Alcock. I represent New England Telephone and Bell Atlantic Corporation. With me is Bill Worth at council table. I would also like to argue the statute of repose, but before I do that, I'd like to make one point in response to a question from Justice Cordy about the applicability of the restatement section 368B. I would refer to the plaintiff's reply brief. And in the reply brief, the plaintiffs make clear that they have no quarrel with the judge's application and use and employment of Section 368B to analyze the foreseeability issue in this case. They concede that point. That's the way the case was briefed below on summary judgment, and that's the way it's been presented to this Court on appeal. Turning to the statute of repose, I would refer, Justice Greene, to your question as to how do we match up the allegations of the complaint to the statute. I would also reference for the Court the plaintiff's answers to interrogatories, which are in the record. Those answers to interrogatories make clear on pages 364 of the appendix that the sole claim in this case is a claim based upon the historical placement of the pole at the time of its erection in 1968. Those answers to interrogatories make clear that there is no activity post-1968 which is the basis of any allegation against the utility companies in this case. The sole claim presented by the plaintiff is limited to the engineering of the pole and its placement at the time of its erection. And as a result of the plaintiffs narrowing their claim to solely that issue, this case falls squarely within the statute of repose. There is no post-erection activity.
But I really am having a hard time understanding this argument, because if I have a building built for me, and it's negligently built, and it's a hazard to anyone who walks on my property, years pass, fortunately no one comes on my property, so no one is injured. Then someone comes along and they're injured because of the negligent design. All right? My property, I own it. I've maintained it as a negligently designed property. Surely I can't sue, after so many years, the contractors and the engineers and the designers, but surely I can be sued for having negligently designed property, having a hazardous risk on my property. Can't I?
I think you would be sued for negligently maintaining your property.
No, I've left it in just pristine, unreasonable condition.
The answer to that question was decided by the appeals court in the Soning case. where the Mass Turnpike was sued in its capacity as the owner of the turnpike for a negligent engineering decision, the absence of a right-hand off-road. And in that case, the appeals court was very clear, saying that the turnpike could be sued in its capacity and its obligations to maintain the roadway ongoing. But if the claim is simply an engineering claim done at the time the road was designed and opened, the turnpike can't be sued for that engineering decision, because the engineering decision, whether it's the owner or the original engineer, is barred by the statute of
So in
repose.
other words, the statute covers, this notion that it covers only engineers and architects isn't right. It covers the owner.
Oh, it does. The owner's...
Because the owner is sort of derivatively in the shoes of the engineers that did this.
Exactly, and that's exactly the role of the telephone company's engineers in this case. The statute, the very language of the statute doesn't exclude owners. It talks about protected actors.
Are there cases that say that it covers the owner?
The Sonnen case from the Mass Appeals Court.
Which, as you know, we have been asked to overrule.
Well, that's an interesting point.
An amicus has asked us to overrule.
Right. The amicus asked you to overrule it. The Sonnen case, there was no argument in the court below to Judge Haggerty in summary judgment that case should be overruled.
Okay.
There was no argument in the plaintiff's appellate brief.
Okay.
And as the court knows, the amicus can't raise issues that were not raised by the parties
You
themselves.
point all that out.
Well, they haven't had an opportunity to apply because the amicus came in late.
Yes, it came in
Well,
late.
you should send a letter in on that.
If you would like to
Yes,
send a letter, you can.
Because
I
it's
was
an
actually
important point.
Actually moving to strike the brief for raising issues under 368B on the foreseeability issue, as well as the request to overrule the Sonnen case, is not being issued properly before the court in this case.
Okay.
I would also like to point out that the whole issue of the pole being only 6 to 8 inches off the road, well, that is in compliance with the Code of Mass Regulations, and the site is 22 CMR 125.23. And that evidence was also before the motion judge and relied upon by the motion judge in finding the lack of negligence.
What does that regulation provide?
Well, it provides that poles may be placed 6 to 8 inches off of the roadway. And the evidence through the affidavit of the telephone company representative, William Wallace, which appears at page 883 of the appendix, provides that...
Is the code on which you just relied something that you brought before the judge?
Yes, it was.
Okay.
There's evidence in the record. I believe it was in the affidavits by the telephone company,
Okay.
as well as Mass Electric, as well as in the 30B6 deposition testimony, that the pole was placed in compliance with the Code of Mass Regulations. Finally, I'd just like to address the whole argument that made by the plaintiffs that the erection of the telephone pole was not an improvement to real property. I think clearly the telephone pole, which provided both electrical and telephone service to the general public for houses and businesses in the area, was an improvement to real property, and there are numerous cases cited in the brief in support of that proposition. If there are no other questions, I will rely on the brief.
Thank you. Mr.
Thank
Alcock,
you.
before you sit down, and it's not you alone, but there are a lot of counsel here, and this is web broadcast. There are certifications required that appellate briefs comply with the Massachusetts Rules of Appellate Procedure. Those rules require that copies of statutes referred to in the brief be part of the brief. None of the briefs in the first case this morning and many of the briefs don't have those statutes. It's really irritating to us when there's a certification by counsel and, in fact, it hasn't been complied with. So in the future, please, not just you, but to the assembled counsel here, please try to get us the statutes.
Yes, Your Honor.
Send in a letter on that overruling point.
Yes.